Well, thank you very much for that introduction, and thank you very much for the invite to be here today. My subject that I was given is why violence against women is a human rights and equalities issue, which is a rather large topic, but let's see if I can cover it in the time allocated. So what I'm going to do is start with a case example, just to try and give what I'm going to say some focus and to bring it back to the women that we would see through the Scottish Women's Rights Centre, for instance, and the other projects that we deal with. It's one that you will recognise. We call her Paula. What you can see there is the usual characteristics of the continuum of violence, the control that's still exercised, and the most common things that crop up to us, to me and my team as human rights lawyer when we engage for the first time with a woman in this situation are two things, and they've been touched on already today. One, a need to feel safe, and that often comes from accommodation. A need to be able to exit that situation or to have the perpetrator exit that situation and to know what her options are around about that. And the second thing is to know what to expect, to have the information about what will happen with the criminal justice process or other areas of advice that she will need. So, why is Paula's case a human rights or an equalities issue? As the Cabinet Minister has just said, international European law, human rights law, makes it clear that freedom from violence is a fundamental human right. And the right to protection from that and to physical integrity is recognised in all major international and human rights agreements. It's contained in our international law. It's contained in our Council of Europe legislation, European Human Rights Convention, the Istanbul Convention. And when we look at the amount of rights that can be breached when we're talking about violence against women and girls, there is quite a high number, ranging from the right to life, including the right not to be discriminated, and it also will impact on a huge array of children's best interests, right to have a healthy, right to be healthy, right to work, right to education. It's hard to imagine how violence against women and girls cannot be seen as a fundamental human rights issue. So why am I here? Because it's quite a simple answer. I could do this presentation in a few minutes. Why is it a human rights and equalities issue? Quite simply it is. But on the front line, as you will know, it is not often like that in practice. Whilst we have a clear commitment from the Scottish Government, and that's already been touched upon, in terms of this being a human rights issue, in terms of this being linked to equality and discrimination, what me and my team often see time and time again when we're confronted by Paula is that no one views it as a human rights or an equalities issue. When we're looking at how to access accommodation or how to give her information or how to improve our experiences with the systems we have, it is very rare to hear someone say, isn't that a breach of her human rights? Don't we have a tool, a human rights toolkit that we could use here? Or couldn't we use equalities law in order to improve Paula's situation? It is very rare to hear that on the ground. It's rare, and I include lawyers in that. Only a couple of years ago, we had a relatively significant case, and we had to explain initially to the court why human rights were relevant in the violence against women case that we were putting forward. So there is a need for a kind of cultural or societal shift so that when we look at this issue, when we look at Paula, we automatically think about human rights and equalities. But I also think it's important to understand why we maybe don't. And that's a kind of, there's a historical context to this. It wasn't until the late 80s that violence against women and girls was even seen as being within the domain of human rights law. The first international convention, CEDAW, the Convention to Eliminate Discrimination Against Women, doesn't even mention violence against women. It wasn't until 1992, 1993 that we seen the UN bring this in as a human rights issue. Now, that's important, because that means we're playing catch-up. And even it was noted in my introduction that I did a master's degree in the early 2000, a relatively prestigious degree, and I recall being taught by the Special Rapporteur for Torture at that time, and he did a session on why violence against women and girls could not ever be a violation of torture and, and potentially even inhumane or degrading treatment. And that was very much the way it was viewed in early 2000, and we certainly have moved away from that. The reason it was viewed like that was because breaches of international human rights law were seen to be about state. It's the government that must breach, whereas violence against women and girls is often caused by private individuals. But we've very much moved on. Because of the prevalence of violence against women and girls, where it is systematic, where someone is not protected, then that is now viewed quite clearly in international law as a state violation of human rights. But it still needs to catch up. We see it in the European Court of Human Rights. There has never been a case involving violence against women and girls where there has been a breach of Article 3, that's the freedom, the right to be free from torture, inhumane or degrading treatment. Nearly all cases are taken to that court stating there's a violation of Article 3 and there's a violation of Article 8 for a variety of pragmatic reasons, normally down to a state agreeing that there's been a violation. Often decisions will say there's been a violation of Article 8. And what that creates, not deliberately, is a perception that people think, oh, well, it's okay for us to have that lower violation as long as it's not seen as an Article 3 violation. A couple of weeks ago, I was at an EU event looking at anti-trafficking and why it should be seen as violence against women, and how we can use different EU instruments to provide a gender-sensitive approach. And quite a few representatives from member states said that their governments did not believe in putting in place special measures or putting more funding into a refuge, putting more funding into support, because they viewed it as a violation of the principle of non-discrimination. They're required to be equal access and not favourable treatment, which is wrong. But it really struck me that even now, even a couple of weeks ago, that we're still dealing with that. So the kind of historical context of equalities and international equalities in human rights law, it not being a part of it, and then it kind of being a part of it, and then it's still kind of working up there, I think provides a context as to why it really is not that automatic thing that we think about when we look at Paula. And indeed, the explanatory report to the Istanbul Convention says that violence against women and girls is a human rights violation shrouded in silence. So we have some work to do in terms of ensuring that it is an automatic response. And in order to do that, we require to raise awareness as to why is it important? Why is it important to Paula? Why are human rights important to those who provide services? Why is it everybody's business? And they matter because, as I touched upon, it may be private individuals who are involved, But if Paula is looking for assistance and she does not get it, and there is a failure to prevent or to protect her, then the law is unequivocal now. That will be a public authority, a government breach. And to be compliant with human rights and equalities law, we must have a sufficiently robust legislative framework to deal with violence against women and girls. We must ensure that when Paula is asking for help, we identify that she is a survivor and we take action to protect her. It's not good enough to say, not sure about your immigration status, we can't provide you with accommodation, or isn't any room here. If we know that our actions are leading to her returning to a situation that engages human rights, then we are talking about a potential breach of human rights law. And we must also ensure that it's investigated and, if possible, prosecuted. The law is clear. That's what it demands of us. And I've already touched on what it means for Paula. We need to provide her with what she needs. There needs to be effective legal measures in order to allow her to engage with the criminal justice process, to take civil remedies, to take actions if that's what she needs to do. What I will say about that is we're not in the business of wishing to challenge public authorities because they've either not been compliant in supporting Paula. And it comes back to that raising of awareness, trying to provide information, raise awareness about human rights, why it's important, and to do that at all levels, so to provide information to Paula, but also to provide information to those where she may be going to ask for help. And there is a gap here. I mean, there is an access to justice gap, as I would call it. We have increasing presentations of women and girls affected by violence. Those presentations are increasingly complex. We have resources going down and this going up. Yet, human rights law demands that Paula has access to information in a way that she understands, in a format that she can get at, to understand what her rights are. Because the most prevalent human rights breaches come around because no one understands what her rights were and the responsibilities of those to provide for that. And also, specialist provision is required. Women and girls are affected disproportionately. They face numerous barriers, which is all known in this room. But human rights law demands that special provisions are put in place. It does not fall foul of the principle of non-discrimination if you have an objective reason as to why you're putting in place more favourable provision for women and girls. We also have a lack of specialist lawyers. We do trained in human rights and that kind of gender-based. When women phone the Scottish Women's Rights Centre, we have one chance, as you all know, to impart that information and to impart information about rights in a way that that woman feels able to act and act in an informed way. And why does it matter to you? Well, if you're a public authority and if you don't do it, we have a toolbox. I mean, there is a human rights toolbox. Paula could take action under European Union law, pre-Brexit. She can take action using the Human Rights Act in a court of law. She can seek compensation if there has been a failure to protect her. So there is a toolbox that is there for her. But more than that, human rights law, in the international framework, it doesn't mention human rights just for the sake of it. It talks about human rights and the requirement to protect human rights and to use a human rights-based approach because it's necessary. Only if we do that and we practically put that in place are we going to eradicate eliminate violence against women? Are we going to ensure that women feel secure enough to report matters, to make complaints? So it's there for a reason. If we don't view it through a human rights and equalities lens, then we're not going to tackle it. And there's been much said today about the impact of that societally on resource, public health, etc. So yes, Paula has a toolbox that she can access if her human rights have been breached. But more than that, if we don't view it through the correct lens, we simply will not eradicate it. And the international frameworks, the conventions, that's them catching up. You know, they realise that. And that's why, you know, we're increasingly seeing it viewed as a human rights issue. I've mentioned a human rights-based approach. So quite often you might see some criminal justice directives from Europe. They're not human rights directives, but they will say that a human rights-based approach must be prioritised. So anyone that's working with Paula must use that approach. And I do think there's a lack of understanding about what that means. I think it sounds quite complex and quite scary, when actually in practice it can just be a couple of practical things that are put in place. But I think when people hear a human rights-based approach, they go, and also I think it can be viewed as a conflict, because on the one hand I'm standing up here saying that if public authorities don't identify, don't prosecute, etc., that could be a violation of human rights. But I'm also saying that international and European law says that in doing so, we must protect the human rights of that individual. And that may be not engaging with a woman too quickly, etc., etc. So I do think in the work that I do that isn't as full an understanding as there could be about what do we mean by a human rights-based approach, what does that actually mean in practice, and why is it necessary, and why is it not a barrier to investigations, etc., that we need to do. And I guess what I want to say about this slide, and I've trained quite a lot on this in Europe, is within a lot of the calls to the Scottish Women's Rights Centre are about fear of the criminal justice process and a feeling of disempowerment within it. And there's a lot of debate in Europe and in this country about the rights of victims in that process. Because often, my opinion, there has been an over-focus on the rights of the accused, the right to a fair trial and all of the rights that go along with that. And obviously, without prejudice to that, a woman and girl who's been a victim of violence also has human rights, and they must also be considered within the criminal justice process. And we really need to take some practical steps to ensure that her rights are considered alongside the accused. And I think, you know, the Victims' Rights Directive and certain legislation, and there's been some practical steps mentioned today about how to start doing that. But for me, there needs to be a bit of a rebalancing in terms of how we view that. And just to quickly touch upon, I've spoke a lot about human rights, but also to make it clear that gender-based violence is a form of discrimination, and it is linked to gender inequality. And the international framework, the jurisprudence from the European Court of Human Rights, which we must take into account, the Istanbul Convention, makes that absolutely clear. If we do not tackle inequality, we're not going to tackle violence against women and girls. And I spoke about the Human Rights Toolkit that Paula could have access to, while the Equality Act 2010 provides another. And again, I never hear this mentioned when we're talking, you know, when we're looking at Paula or we're looking at systematic issues. I very rarely hear, and what about the public sector equality duty? Very rarely. But it applies. And the Equality and Human Rights Commission have technical guidance around about the Equality Act, and they make it clear in that guidance that human rights and equality are so interlinked that it's good practice to deal with them together. I could have a whole session on this, but as an overview, there's a general duty to eliminate discrimination, and then there are 9 specific duties relating to reviewing and reporting and publishing of information. But it absolutely recognises that public authorities, you know, where we have systematic issues, systematic data, then that must be taken into account when planning services, when planning a response. And a more favourable response to women and girls should not be shied away from. Indeed, human rights law and equalities legislation may demand it. And case law around about this equality duty in England has made it clear that it not only applies when looking at the formulation of policy, but it also applies to specific decisions. So that decision to do or not do something with Paula, that is someone acting as a result of a policy. And that action could also be in breach of the public equality duty. So that could lead, again, to a court action or indeed enforcement action by the Equalities and Human Rights Commission. So I guess, in conclusion, it is definitively a human rights and equalities issue, but you knew that. The key is to ensure that it is automatically viewed as that whenever we're talking about violence against women and girls, human rights and equalities are in that same sentence. We need increased awareness about the rights of women, that these come from a pretty strong framework where there are compliance. You know, if there's non-compliance, there are sanctions, there are actions that can be taken as a result. And to ensure true equality of access, we do need specialist services, networks such as this, in order to provide support and target this issue. And just to finish, just some information about the Scottish Women's Rights Centre. When our national helplines are open, in case you're not aware of that, it's a free helpline for any woman affected by violence to contact. Thank you very much.